that's busy and deciding whether we should be grey listed, I asked one of my colleagues, Llewellyn Stevens, to talk us through this, because he's got his finger on the pulse and he is checking what is happening with our status as it relates to the Financial Intelligence Centre Act and as it relates to the international money laundering regulations and listing. So I've asked Llewellyn to do today's talk for us, because he's the clued up guy, he's the attorney that studies these things and studies the trends and knows exactly what's going on with regards to the legislation. So he does the training for our staff as well. So he comes in, he goes to our secretaries and he shows them and teaches them and informs them as to what they should do in terms of the new legislation, etc., etc. So I'm going to hand over to Llewellyn, who's the expert, and I'm also going to sit in and listen to his talk, which is always very interesting. So yeah, thank you so much, Michelle. And I'm going to hand over to Llewellyn. I just want to have a look whether his slideshow works. There we go. Llewellyn, do you want to join us? Yeah. Yes, on the screen. You have to click on things. I can see it doesn't. Okay, but there we go. There we go. So it's the right button.
Ladies and gentlemen, good morning. It is so great to be with you this morning. I really want to say thank you to my colleague Hein Daisel for the lovely introduction. I am definitely not the expert that he claims me to be, but I have read up on the FICA greylisting and the new money laundering bill a bit, and I'm quite passionate about this. We've seen so many controversies in the recent past about this matter. Fines imposed both on property practitioner agencies as well as law firms. So I think this is such a relevant topic. It's an important topic and really something that we need to keep updated with on a weekly basis, actually, because it happens fast. There are a lot of developments, both on a national but also a global level. So it is really a privilege for me to be with you this morning. And I really hope if there's one thing that you'll be taking from today, I will have my job, I've done it well. So thank you so much for joining us. I know Hein is the favorite with Leapfrog, but I'll just come and do my part for a bit, and then I'll give you back to Hein. Michelle, you can all hear me very well?
Sound is perfect, Llewellyn. We're looking forward to your presentation.
Lovely, great, thank you. Then without any further ado, let's jump in head first. So this is actually, I purposefully left it in this way, but this title that's there is actually not entirely the truth. We speak about FICA greylisting and the new Money Laundering Act, because on the 22nd of December last year, the president actually signed this bill into legislation. It's enacted, approved by all spheres of parliament, both the National Assembly and the National Council of Provinces. So it is indeed the new Money Laundering Act, but we will get to that in a second. So, as you would perhaps know, the Financial Intelligence Centre Act aims to enable the combating of money laundering activities and the financing of terrorist and related activities. So, I think, as we've seen, let's just call it, for purpose of this session, dishonesty and people wanting to steal, a lot of amendments have been made to the Act, And it's specifically needed to ensure that South Africa meets international anti-money laundering standards. So, as I said, this is unprecedented in my opinion, and this is why we need to keep updated all the time and regularly with all the new developments coming literally on a weekly basis. So the amendments, and particularly those that we will be speaking about this morning, are necessary to ensure that South Africa's avoidance of that we stop from being grey listed. So you might ask, what is the meaning of being grey listed? The global, like Heinz said earlier, the Financial Action Task Force is the watchdog in this regard. They are the global money laundering authority that keeps watch over all countries' actions. I think there are about 39 countries with them. They are based in Paris, and this FATF was actually established in 1989 already. So what it means is when a country is put on the grey list, it means that it is under increased monitoring by the FATF. A country having landed on the grey list means that the FATF has identified strategic deficiencies in its systems to counter financial crimes. So the issues that the FATF was looking at were particularly due to low levels of transparency and inadequate internal capabilities and systems, which led for South Africa to be placed under review by the FATF and on the brink of being grey-listed. Han just told me this morning he heard on the news that there will be, apologies, gather next week at the headquarters in Paris to make a final determination. So I really want to say from the get-go, it is literally yourselves as property practitioners, us as legal practitioners, all of us need to work together and do our part to ensure that we don't reach that status. So when a country is put on the grey list, the country is closely monitored, like I said, and stringent regulations are imposed on those countries. A country being placed on the grey list faces serious potential problems, such as lack of trade opportunities, a downgrade of ratings, and a subsequent shrinking economy. And I want to say on this point that with these high level of regulations coming in, I just had a client last week that wanted to purchase. They are purchasing a property and wanted to bring monies into the country. So we appointed one of our partners that deals with repatriation of funds and bringing money into the country. And the number of questions that they asked are, I cannot even explain it. I will go as far as to say it's a foreign company that is the purchaser, based in Finland, and this company, obviously, they also have their regulatory authorities. They even asked for 2 years of bank statements of that company, foreign company, and all the details of all the directors and shareholders. So this is what we're dealing with. This is where we are, where we've come due to many factors. So that is just one example of how this now played out and where it brought us. I also wish to mention that a recent report by Business Leadership SA has concluded that the chances of such grey listing for South Africa are 85%. And according to the report, South African clients will then become subject to enhanced due diligence, like I just explained, which will mean more frequent and more invasive assessments for anti-money laundering and combating of terrorism financing measures risk. This will lead to higher costs for South Africa, for South African businesses, both for yourselves, for us, and for the clients ultimately, for clients and individuals that wants to trade internationally, and the bank and investment accounts also much more regulated and much higher. So in addition to what I've just mentioned, managing correspondent banking and global infrastructure, such as payment providers, relationship managers, will come at a higher cost to banks and to your clients, which is the one thing that we want to avoid. It is estimated that the impact of these costs will result in a decrease in the gross domestic product of between 1 to 3%. So a serious and urgent government-wide effort to fully implement the recommendations and the action points of the task force will be implemented, and we will have to comply with all those requirements to avoid being grey-listed. There is always a silver lining. If South Africa is perceived as being inactive in addressing these concerns, then the cost will be high. Obviously, if we strap the seatbelt and we get our act together, then we will avoid being grey-listed. But like I said, all of us need to work together. The task force valuation was concluded in October 2021, and I just read earlier this week that our Minister of Finance actually also had engagements with the task force earlier this year, in the second week. And yeah, that valuation found holes in our strategic systems, like I've said. And on the 14th of October last year, the Minister, in terms of the FIC Act, made amendments to the money laundering and terrorist financing control regulations, which came into force on the 14th of November, and like I said, enacted by the President on the ultimately on the 22nd of December. Regulations forming part of or next to the Act. So this is, you can see on my screen, I just gave you a brief timeline of events. So a lot, I think the one thing I want to bring across, that a lot has been happening. A lot has been happening to bring us to where we are today. And it's both you and my job to ensure that we stay safe. So I want to briefly touch on the amendments. So in terms of the amendments, which we will look at in a second in more detail. In terms of the amendments, the prescribed amount for reporting cash transactions under Section 28 of the FICA to the FIC has been increased from 25,000 to 50,000. A threshold where you now need to report possible, if you have any doubt. I always say to my colleagues, if you have any doubt, and I can tell you now, you can feel it in your water. You just have that suspicion. Rather report it. Cash transactions above the threshold must be reported to the FIC as soon as possible, but not later than 3 days after becoming aware of a fact of such a cash transaction that exceeded the threshold. Greylisting indicates the risk that the rest of the world attaches to South African companies and individuals as counterparties to transactions. Now, just to look at the amendments briefly, like I said, this is the entire Act, the General Laws, Anti-Money Laundering and Combating Terrorism Financing Amendment Act. It improved mechanisms to collect beneficial ownership information about companies and trusts. I will speak about that in a moment, but I want you all to make a mental note of it. Beneficial ownership, I will also elaborate on, but it boils down to, we need to identify all the parties, especially if it's an entity, a trust, the trustees, the beneficiaries, the donor, all of the parties to that must be identified, and we must obtain all the FICA documents. So then the amendments will also give the FIC new powers, including access to a range of records from various institutions. The bill also then aims to provide for the disclosure of the beneficial owners, like I just said, and the ultimate controllers of trust companies and non-profit organizations. And finally, the definition of accountable institutions is also addressed by the Amendment Act. So for purposes of this discussion, we will only look at the amendments to the Financial Intelligence Center Act, but as you can see on your screen, there are a whole bunch of other pieces of legislation that were also amended. And ultimately, These are not mutually exclusive, especially in our trade. You always look at the Companies Act and the Trust Property Control Act in addition to the FICA. So, the amendments to the definitions in FICA have taken effect, and in particular, the expanded definition of beneficial owner. So, like I said, those with less honorable intentions may look for opportunities to retain control over criminally derived assets by inhibiting the ability of law enforcement to trace the origin and ownership of assets. This being companies, trusts, other similar legal arrangements, any entities where more than one person is involved, they are seen by criminals as potentially useful vehicles to achieve this outcome. Obviously, it's much easier, and there are many ways of doing it if you use the entity than you're doing it in your own accord. So the task force defines a beneficial owner or an ultimate beneficial owner as the natural person who ultimately owns or controls a customer and or natural person on whose behalf a transaction is being conducted. It also includes those persons who exercise ultimate effective control over a legal person or arrangement. So typically, a UBO, ultimate beneficial owner, is the majority shareholder or a person who holds at least 25% of shares in the company, but not all entities have a majority shareholding or even shareholders at all. For example, if we look at a listed company that has thousands of shareholders with no clear majority holder, then you might look to the CEO or the CFO or the chief operations manager as having the ultimate control. For a residential estate management company or club or association, in those regards, you might look at the elected chairperson, but also then the treasurer, because ultimately they also have say and influence in the decisions being taken of that entity or that body. For a trust, you would first look to the donor to understand who and where the assets come from, followed by the trustees and then the beneficiaries, like I said. So in this regard, ladies and gentlemen, we need to identify those ultimate beneficial owners. We need to identify the donors. We need to identify the directors having influence and having control over the company. It is not sufficient just to identify the person in whose favor the resolution has been signed and issued. All the ultimate beneficial owners need to be identified. So as attorneys, we will be asking for that, but you being an accountable institution in terms of the Act, there's also an obligation on you to obtain that from the start, as soon as you take mandate. Section 21 of the Act, it empowers the centre to enter into public-private partnerships for the purposes of achieving the objectives of the centre. The FIC's power extends to being able to request information or access any database held by any organ of state, and also having access to information in a register that is kept by such state. Then, amendments relating to CDD, to customer due diligence. Section 22 of the Act amends Section 21B to expand and clarify the customer due diligence measures for legal persons, trusts, and partnerships, like I've explained briefly just a second ago. Section 23 of the Act amends Section 21C to provide that if an accountable institution, both you and I, suspects that a transaction or activity is suspicious of Section 29 and reasonably believes that performing the due diligence measures in terms of 21C, they will disclose to the client that a STR will be made to the FIC, and it may discontinue the due diligence process and consider filing an STR, suspicious activity report. I think for us, as for you as property practitioners, for us as legal practitioners, it's just not worth it. As we say in Afrikaans, die kool is die sous nie werd nie. If you have any form of suspicion, rather report it or ask for even more documents until you are satisfied. And if you are not, then rather just let it go. I know this is not a popular opinion to give you, and please don't tell Aniki and Hein that I said it, but we've seen the fines in the news that has recently been issued, and I have at least 3 of our agencies that I know of that's being assessed by the FIC at the moment. So I think it's just not worth it, and especially the onus is so much more on you and I now to do that due diligence. We cannot really just throw the ball into the client's court anymore. And then finally, the FICA is also amended to provide for immediate enforcement of the resolutions of the United Nations Security Council upon the adoption of the resolution. That is, in short, it, ladies and gentlemen. I think the most important updates that you need to know of the ultimate beneficial owner that you're doing your due diligence there on. So in closing, I wish to say that we need to follow a risk-based approach. There's one thing that you're taking away from the session this morning is that you need to take a risk-based approach. Keeping the relevant documents such as IDs and proof of address on your file is just not sufficient anymore. We need to verify that the documents have not been tampered with and that they indeed contain accurate information. We need to apply the risk matrix and establish risk. And then also the system must check, you must have an internal system in place, and obviously your RMCP, to ensure that the client's information against international lists is also checked and verified to make sure that there are no terrorist-funded transactions. Beneficial ownership has to be established. Entities, trust, those 2 are in particular a major concern. So emphasis has been placed on directors, members, shareholders, trustees, beneficiaries, and the founder, that they be assessed in terms of the KYC, the Know Your Client principle. Continued verification of legacy clients, those purchases, the purchases that purchases today, and in 3 years they come back as sellers and they say, no, Michelle, you've got all my details on file. They are still the same. Nothing has changed. And I think that those are the kind of relationships that we wish to nurture with our clients, build rapport with them. But that is unfortunately not that won't fly, as they say informally. We have to obtain all the documents again. New documents, see if their status has changed. So yeah, legacy clients in particular needs to be addressed as well. And then finally, like I said, the RMCP policy, if you need any assistance with that, we are more than welcome, more than willing to assist you with that and to ensure that that is also updated and that you stay on top of what is happening in the legal and in the property fraternity. And yeah, I think if I can summarize it in one sentence, it's trust your gut, beware, and do your due diligence. The onus is on you, and the onus is on us. You as legal practitioners, on us as, for you as property practitioners, for us as legal practitioners, the onus is on us because we, in our own accord, have to account our regulatory authorities. So I hope you don't see this as a daunting task, but rather as encouragement that we cross all the T's, that we dot the I's, and we will assist you through the entire process. If you have any questions, please do not hesitate. You have all our details, Heinz and Aniki's, and rather ask and let's be safe rather that we run into a challenge a month or 3 down the line. That, ladies and gentlemen, includes my presentation for this morning. We didn't want to keep it too long so that you can take in all the information. Are there any questions at this point?
Yes, I've definitely got one, and I think it's a question that a lot of the agents are also going to be asking. Can you maybe give us a little bit of background as to why we are now potentially going to be going onto what what you spoke about in the beginning, a grey list? Is it because of has the volume of suspicious transactions increased in the country? Because obviously, if we're going on a grey list, it means there is a problem, and we've obviously got serious money laundering issues. So I think that's my first question. And then my second question that I want to know, and I don't know, I must live in a bit of a shady suburb, but I've got 2 drug lords living in my road. And let me tell you now, they are driving 7 million rand cars. Now, they're definitely not getting finance, because I can tell you, they're definitely not proving income, which means they're buying them cash. So are cars, when you buy a car, is that exempt from being FICA? I don't know.
No. Michelle, let me answer your first question in this way. With the implementation of, you would know, recently, the FIC Act, the POPI Act, all these recent regulations and measures that were put in place over the past, I want to say 3-4 years, now those have come to the fore. Now those suspicious activities have come to the fore, and have there's an emphasis placed on it. And then also what we need to say, and I'm going to say this as friendly as I possibly can, but also the government and their spending and all the issues in this country that we know of. So yes, to answer it in short, I know it's always been there. These suspicious activities have always been there, but only now, with all these measures being put in place in terms of FICA, in terms of POPI, now they've come to the fore. They are being recorded. We can see the amount of suspicious transactions that's being logged and reported, and as such, there is this emphasis on the FA from the task force on South Africa now. It is difficult to say. I know that the Minister of Finance and all of them, I think they're working hard to avoid us being grey-listed. We will have more clarity on that come next week. But I think at the end of the day, I want to bring across is it is every single person's job to make sure that you tick all your boxes and that you do what you were supposed to do. I know we've got a very far way to go with that. Everyone's moral compass are maybe not in place as some others would be, but that is the short and the long answer. There wasn't any regulatory authorities in place and measures in place in the past, and now there are. If I see walks into your office and they say, I want that file, give it. And if it's not on there, then if the FICA is not on the file, then you will have trouble. So I think also the media also has a big influence on that. I think this gets large media coverage, which also attributes to that, but 85%, but I don't think for now we should be too worried. We can only do what we need to do. And then I'm going to let Hein answer the question about the drug lords.
But let me just, with regards to the grey list, you know, when I heard about the grey list, I thought, well, put us on the blacklist. Who cares? Who cares about grey list? But it's so important. Countries that are on the grey list are countries like Afghanistan, Syria. I mean, these are countries war-torn. I mean, we don't want to be associated with countries like that. No country out there will do business and trade with South Africa if we are on a grey list like Afghanistan, Syria, etc., etc. So it's very important not to be on the grey list. It's very important that the Financial Intelligence Center crack down on companies that do not do their work, because the task force has said, guys, you've got all these rules and regulations, but you guys are very lackluster in enforcing these things. You don't ask questions, you don't investigate funny transactions, you just let it be bygones and let it go by. You guys need to report these things in order to avoid people investing in your country for money laundering purposes. And then, Michelle, the drug lords with regards to the cash, I was excited about the BMWs and stuff like that. What was that question again?
Question is, and as I said, it's not real estate related, but I always wonder. I mean, I have one in my street that's driving an 8 million rand car.
Yeah.
Now, there's no ways they're applying for financing because they're not trading in a legal business. So how do they actually buy these cars? Because
Absolutely. So those car companies that they bought it from, like Wingfield Motors, whoever, those guys should be asking the question and say, listen here, 8 million rand, where is this money coming from? Where are you employed? Can you show me, did you sell a property? Yes, I sold a property, or I inherited money. Well, then show us give us the detail of the executor. Give us a letter from the executor confirming that you inherited 10 million rand. But that is what we're not doing. And that is what the task force is saying, guys, you need to come to the party. You need to ask these questions. You need to find out what the risk is. You can't just say, oh, it's personal savings. No. You must prove it to us. Where are you employed? Give us some salary slips to show that you earn a decent income. Ask some questions, get some information, put it on your file. And if something is funny, there is no way now that from the salary slip he earns 10,000 rand a month, that he can earn an 8 million rand car. There's no way. Then Wingfield Motors, unfortunately, you have to report it to the Financial Intelligence Center so that they can do the investigation and see what's going on. Because no one will say, Wingfield Motors, you reported us. No. That happens behind the scenes. Just report it, and FICA will take it from there to investigate the matter. So yes, Michelle, guys, if it's a cash car that they bought, people like Wingfield Motors, etc., should investigate it. They should ask more questions. Because how can you afford an 8 million rand car? You need to provide us proof. Where the heck did you get this money from?
Michelle, yeah, I think you say, well, these guys don't do it. They get away with it. At some point in time, you can go read the news. These authorities are knocking on people's doors now. They're knocking on people's doors, and if you can't provide that, you will meet the full extent of the law. So I think for us good citizens, active citizens, law-abiding citizens, don't be discouraged. There will come a day where they'll have to answer.
So FIC will walk into the offices of Wingfield maybe and say, Wingfield, these guys are very suspicious. We realized, we found out that they bought a motor vehicle through you. Give us your file. What investigation did you guys do as Wingfield to find out where does these finances come from? Oh no, we only got their ID and proof of residence. That's not good enough anymore, guys. You need to investigate. And if it's a risky or fishy transaction, you've got to report it. So they are clamping down on so that we don't go onto the grey list in order to enforce these rules and regulations. Yeah.
Both, I think that was extremely informative, and obviously, I think the responsibility here is on the agents just to do, as you said, the due diligence, keep their slate clean, and do what needs to be done.
Absolutely.
Thank you so much, Hein. Thank
Michelle,
you both.
thank you guys. Thank you, Llewellyn. Thank you so much. Enjoy the rest of your meeting, and I'll see you guys next time.
Absolutely. Llewellyn, we loved your smile. You could light up a million light bulbs.
Thank you, Michelle. I'll definitely come and pop in again with Hein.
Anytime.
Thank you,
Thank you
Michelle.
so
Enjoy
much.
the rest of your meeting. Keep well. Ciao.